In this video, I want to take a look at something that I'm regularly asked by both employer and employee, and that is, how much notice do I have to give? This is a question that comes up regularly, as I say, from both employers and employees. That's what I'm going to look at in this video. Okay, the relevant statute in relation to notice is the Minimum Notice and Terms of Employment Act 1973. It sets out the minimum statutory periods of notice. Now, I emphasise statutory because there may be contractual periods of notice as well which exceed the statute. But from a statute perspective, if there's nothing in the contract, then the minimum notice that you're entitled to as an employee is 1 week if you've worked for less than 2 years. If you've worked for more than 2 years and less than 5 years, you're entitled to 2 weeks. If you've worked for more than 5 but less than 10 weeks, you're entitled to 4 weeks. If you've worked for more than 10 and less than 15, you're entitled to 6 weeks. And more than 15 weeks or more than 15 years of continuous service in the employment, you're entitled to 8 weeks. Now, I will state again and emphasise that they are the minimum statutory entitlements. If the contract of employment says something else that is greater than those minimum periods, well then that applies. In relation to the employee giving notice to the employer, the minimum is 1 week. But again, I would emphasise that the contract may take or may supersede the statute by giving a greater period. So the contract could say, for example, both parties are obliged to give 1 month or 3 months or 2 months or whatever. If that's the case, well, that's the case. Now, both employer and employee can agree to waive the notice period. So if you're an employee and you have been offered a new job and the new job wants you to start in a fortnight and you have to give a month's notice period, the employer, your existing employer, can waive his right or her right to the notice period of, say, 1 month or whatever. Section 8 then of the Act sets out that there is no notice period that the employer has to give in cases of misconduct. However, I would caution employers against trying to rely on this, because the misconduct would want to be fairly gross, fairly egregious, fairly grave in order to justify no notice whatsoever. I would guard against it. Complaints then in relation to the notice period not being given are made to the WRC, the Workplace Relations Commission, and they can award compensation to the employee for the failure by the employer to give the statutory minimum notice, or indeed the contractual notice. The employee can sue the employer for breach of contract in relation to notice. In other words, if the notice period in the contract is, say, 3 months and only 1 month or 2 weeks or 1 week is given, then the employee can bring a claim to the civil courts and sue for breach of contract, and he or she will probably be awarded the remainder of the notice period that they are entitled to. It cuts both ways though. The employer can sue the employee for the employee's failure to give the required contractual notice period. Now, it's probably unlikely to happen in practice, because from a practical point of view, if an employee gives 2 weeks notice where he or she is obliged to give 4 weeks notice, then the employee hasn't worked for the 2 weeks that they are obliged to work for and they haven't got paid. But from an employer's perspective, they may well just decide to let it slide and not bother pursuing it. However, theoretically, they can sue for breach of contract. Clearly, they would have to show that they've suffered a loss, etc., as a result of the failure by the employee to abide by the contract and give the required contractual notice period. I hope you find this useful. My name is Gorry. I'm a solicitor in Enfield and County Meath. If you do find it useful, please give it a thumbs up down below, or maybe share it with your friends, and you might be interested in subscribing to my YouTube channel. Thanks for watching.